To consider the case of Simpson versus the state of Florida. Counsel?
Thank you and good morning. I'm John Mills, counsel for Jason Simpson, and this is post-conviction challenge to his capital sentence. I'd like to begin today by very briefly giving a court the overview of the facts of this case and a few big picture observations about what makes this case so different from so many cases that come before the court. I'm then going to drill into one claim that I think is the strongest of the many that we put before this court and would provide the most narrow basis for the court to grant relief. And then in the time remaining, I will try to address our remaining cases, or claims. This is the double axe murder from Jacksonville. The victims were a drug dealer named Archie Crook, who goes by the nickname Big Archie, and his pregnant girlfriend, Kimbler. They were killed the night of July 15th or early the next morning, 1999, in Big Archie's bedroom. The state mainly relied on two prongs of evidence to convict Mr. Simpson of the murders. The first was the testimony of Michael Durance, another drug dealer. He came forward 2 years after the murders and said that 2 years prior, Jason Simpson had confessed to the murders to him. Now, Durance at this point was serving a long sentence for cocaine trafficking, and he had learned that he got that sentence because he was arrested as the result of a wiretap on which Jason Simpson was working as a confidential informant against him and had provided information that allowed for Durance to be arrested. In any event, the story that Durance came up with 2 years later was that Jason Simpson told him that he went to Big Archie's house unarmed to kill Big Archie. He waited out in the backyard smoking a bunch of cigarettes at night until he happened to find an axe laying on the ground. He then crawled through the kitchen window with the axe and went into the bedroom and killed the victims. No cigarettes were ever found outside the scene despite a thorough search. And when shown crime scene photographs showing that nobody could possibly have come through the kitchen window, Durance changed his story at trial to testify that it must have been the laundry room window or an interior window between the laundry room and the kitchen. He admitted that he was testifying in the hopes of getting assistance from the state on his long sentence, and he also admitted that he would lie under oath to get that help. The second prong of the state's case was DNA evidence, specifically some clothes that were found 4 days after the murder that had some blood from the victims and some DNA from Mr. Simpson. There was no forensic evidence from within the scene that tied to Jason Simpson. Fingerprints were found, footprints were found, blood was found that they believed came from the assailant. None of that was matched to Jason Simpson, nothing. The murder weapon was found out in the yard, the axe, and it had the victim's blood on it, but it had nothing from Jason Simpson. No fingerprints, no DNA, nothing. A thorough search of the backyard by the crime scene the day after yielded not only the axe, but 2 pieces of black cloth that had torn off onto a barbed wire fence at the back of the property. Despite their search, they never found the clothes. It was 4 days later that a lawn boy for the church, which was just the other side of that fence, came forward to say that he found the clothes just a few yards from where that fence was. And the clothes were found with a pair of shoes and a hat. No DNA from Simpson was ever tied to the hat or the shoes, but was to the clothes. Specifically, there was DNA, including wearer's DNA, on the inside of the clothes, the collar, and such that would wear against a person's skin when you wear it. And that DNA belonged to Simpson. But there were also mixtures of DNA. And the mixtures at those locations showed that at least one other person had also worn the clothes. Now, Jason Simpson was a confidential informant at the time. He was working for the Jacksonville Sheriff's Office, the Clay County Sheriff's Office, and other law enforcement agencies. He had been arrested on a robbery charge himself and had been released early to start working as a confidential informant against people just like Big Archie's son, who goes by Little Archie, and Durance. Simpson's defense at the trial was that Durance is lying and Simpson never confessed, that the reason Simpson's DNA was on the clothes was because he wore the clothes, they belonged to him, but that a few weeks before the murders, he had given them to Little Archie, so he could not have worn them at the murders. And the third part of his defense was that Little Archie was more likely the murderer. Not only had he taken the clothes found at the scene, but there were quite a bit of circumstantial evidence pointing to his guilt. It was a very close case at trial. The jury convicted, but between the guilt and penalty phases, jury Cody attempted to recant her verdict and told the judge she didn't think the state had proven its case. Now, on direct appeal, this court concluded that that had no legal effect, but the point for now is that this was a razor-thin case, and that the prejudice burden for us should be very low, although we could meet the highest one you can come up with. We have briefed 25 claims from our 3851 petition in this appeal, and we filed a habeas petition raising 2 more. This court has 27 claims that it has to dispose of. And I know we've overwhelmed the court with the number of pages in our briefs, the number of pages in the 12-day evidentiary hearing below with 37 witnesses, which is extraordinary, and the overall size of this case. But I'm going to start now with the court's indulgence with just a few big picture ideas about this case that I think put it in context. And then I'm going to drill down into the one claim that I think you can resolve this on based on just a few pages. First off, this is an unusual case in that we have an amicus brief filed both by the National Innocence Project, which has never appeared in this court as an amicus, and the amicus and the Innocence Project of Florida. This is only their 3rd amicus brief. And while we declined to ask them to cede some of our time at oral argument today, would like to thank the authors of that brief for the pro bono time they've given assisting us. And that brief highlights how this case shares many common characteristics with cases where innocent men and women have been exonerated in death penalty cases, not just in Florida, but across the country. The state's answer brief is extraordinary in this case. I've never seen anything like it. It follows an unusual pattern. For each claim, it just restates what the trial court's ruling is. It then provides a neutral, usually correct summary of what the standards are that we typically don't agree with. It rarely addresses any of the facts that we've recited, much less dispute them. And it rarely addresses the arguments that we've made, or even, other than just quoting them, the grounds on which the trial court made. And each section usually ends with just a couple of sentences of argument. I think our reply brief really tied all this up very neatly and should be a guide to all of these cases. And hopefully it will make, in the limited time that I have today, my job a little easier to just focus on a few things with the court. One of the things is this trial court order, as long as it was, you don't have to read anything about the case. You don't have to know anything about the case, but you can look at this order and you can see at least 2 glaring, very important errors, and they both relate to prejudice. First, the court declined to apply cumulative prejudice, saying, well, I didn't find any of these claims were valid, so I don't have to do cumulative prejudice. Well, he denied 2 of the claims. That would be claim 7 and at least a portion of claim 1 regarding Durance's involvement in other murders. The only basis for denying those was prejudice. So you have to have cumulative prejudice. Beyond that, a whole bunch of claims were denied on multiple grounds, including prejudice. That'd be claims 1, 3, 4, 6, 9 through 14, 17, 19, 21, 23, 25, 26, and 30. These are all claims denied, at least in part, on prejudice, and yet there's a refusal to conduct cumulative prejudice review. The individual prejudice review that was conducted by the trial court was equally erroneous. Each time, the court ruled against us on a finding that we had not proven that the constitutional violations would have resulted in his acquittal. But for the constitutional violations, he would have been acquitted. That is not our standard. We do not have to prove that, certainly not on our ineffective assistance or Giglio claims. All we need to prove is that there's a reasonable chance that the jury would have ruled differently but for these constitutional violations and in combination with the newly discovered evidence. The last big picture thing about this case that I think is so important and sets it apart from so many cases you'll see, not just death penalty cases, but any criminal cases, is that the defendant waived his right against self-incrimination and testified. He came here and testified and professed his guilt and looked the jury in the eye. That rarely happens. The reason that rarely happens is even when the defendant is innocent and testifies completely truthfully, it is not difficult for a skilled prosecutor to find minor inconsistencies and make it look like the defendant is lying. The minute the jury thinks that the defendant is not telling the truth on one thing, the case is over. They're going to convict him, and that's exactly what happened here. And that gets me to this claim. The one claim I think you can, in just a few pages, wipe this case out and not have to review all the others. We are entitled to relief on claim 17, which involves Simpson's, the date he was released from prison to start working from jail to start working as a confidential informant. Simpson took the stand, looked the jury in the eyes, professed his innocence, told them Durrance was lying, and gave his explanation for the DNA on the clothes. Durrance's testimony only had any credibility at all when viewed in conjunction with the DNA. So if the jury believed Simpson that he gave the clothes to little Archie and didn't have the clothes, then the DNA evidence is gone. And there's nothing against him except for Durrance's testimony, which is not sufficient as a matter of law to support the conviction. But even if it were, this court should have grave concerns and can have no confidence that the jury would have convicted based solely on that. Now, Simpson testified that he did not remember the exact date of his meeting with little Archie. He knew it was a few weeks after he had been released, but this was all 7 years ago. The trial was 7 years after the murder, more than 7. And so he didn't remember the date he was released, but he said shortly after he was released, he had all the details. Shortly after he was released, he moved to a trailer, and he lived there for a few weeks until he moved to his mother's house. And a few weeks after that is when the murders occurred. And he testified that while he was still at the trailer, he went to his mother's house to paint the house, and little Archie came over. And little Archie and he drove back to his trailer. And along the way, little Archie said, "Hey, are you wearing a wire, man? You just got released from jail. Are you wearing a wire?" Simpson said he wasn't wearing a wire. They get to the trailer, and little Archie says, "Hey, man, I got to go hit a lick." That's a term that means commit a crime. I got to go commit a crime. I need to borrow some clothes. Well, Jason Simpson's job was to be gathering information of criminal activity against little Archie and other people. And so he said, "Sure." And he pointed to a pile of dirty laundry on his floor, and he said, "There's some black sweat clothes there, help yourself." Simpson then went and took a shower, and when he got out of the shower, little Archie was gone, the clothes were gone, and sitting out on the dresser was a business card from the detective that Simpson was working. So clearly, little Archie had found out that Jason was working as a confidential informant. The state challenged this testimony not by contrary evidence, not by saying, "Oh, well, little Archie denied the clothes and you got to believe little Archie." Instead, they attacked it one way and really only one way. They fabricated an inconsistency with his timeline. Specifically, Mark Khalil, the lead prosecutor, and this is at pages 14, 19 to 24, just 5 pages. If you read those 5 pages, you get what the case at trial was all about. Jason Simpson was convicted because he was impeached on his timeline. Mark Khalil said, "You were released in March, weren't you?" Simpson said, "Well, I don't think so, but I don't remember. It's been so long, I can't remember." And Khalil hammered him about March again and again, suggesting that's when it was and why that was so inconsistent with saying it was just a matter of weeks between release, seeing little Archie, and the murders. In post-conviction, we proved that representation by Mr. Khalil, those questions, he had no basis to ask them, and they were false. Jason Simpson was not released from custody in March. Now, he was released from the Duval County Jail in March, but in police custody, where he was taken over to Columbia County, where the state has stipulated now, he was not released until June 9th. And the reason that he was released on June 9th is incredibly important. It's because the same state attorney's office that Mark Khalil works in, the same prosecuting office that put him on death row, went to Columbia County, called the state attorney's office in Columbia County, appeared before the judge in Columbia County, and said, "Mr. Simpson," he was on a violation of probation charge, "would you please release Mr. Simpson so he can come work as a confidential informant for us in Jacksonville?" And that's just what the Columbia County Court did. And on June 9th, Jason Simpson was released from custody. That fits his timeline perfectly, and it destroys the state's case. The trial court denied relief on this case because it said, "Well, hey, Mr. Khalil never put on any actual evidence it was March, so there's no false evidence." Well, we cited many cases that if the state insinuates a false fact, that counts just the same for Giglio, and the state has not challenged that on appeal. Instead, the state has made just a very brief cursory argument that, well, Mr. Cleo made an honest mistake. Well, the law is clear on that. That's the facts of Giglio. That does not matter. It does not matter if it was an honest mistake. Another person in his same office knew the truth. And the failure of them to communicate is not a defense to a Giglio claim. It establishes a Giglio claim. The trial court's alternative rationale was that this wasn't material and it didn't matter. The timing didn't matter. All that mattered was Simpson said that at some point before the murders, Archie came and borrowed the clothes. That's extremely unreasonable, and it is all you've got to look at is the closing argument of the state. The state made it material. The state made it a feature of their closing argument. In fact, on page 1618, Mark Cleo told the jury that the fact he was released in March 1999 is, quote, vitally important. Vitally important means much more than material. But he didn't stop there. Look at pages 1643 to 1644. This is what Mark Cleo said about the March 1999 false release date. He told the jury this is, quote, the most important inconsistency of testimony. And he told them this was because Simpson had, quote, said definitively it was in the first 2 or 3 weeks after I got out of jail that I was staying at the trailer. He criticized Simpson for not putting on evidence to show that wasn't true, put the burden on Simpson and said, well, since he said when, quote, I'm still on page 1644, when directly confronted about this blatant inconsistency on the witness stand, he then has to hedge back. It's been a long time. Defense counsel wasn't prepared. They should have been prepared. We have an alternative IAC claim. I don't think you need to get to it. They had in their own files his release date. It's easy to get. We had no trouble getting it. But defense counsel didn't try to correct it at trial, didn't tell the jury there's no evidence of the March 1999. He just didn't admit it. So on rebuttal, look at what Ms. Nelson, the second chair prosecutor, said. He said they don't have any answer to it, and that tells you Jason Simpson was lying. And then if we have any doubt at all, the head of the prosecutor's homicide division wrote a memo. It's in the evidence in this case. He wrote a memo to the office that said, Mark Cleo did a great job. He secured this conviction through his cross-examination of Jason Simpson. There was nothing more material in this case to the defense than Simpson's testimony, and the only way they convinced this jury to disregard that testimony was through a false representation. Real briefly, the state has come up with a couple of novel arguments in its answer brief that I'd like to quickly address. The first is they say that testimony from Detective Henson at trial showed that Mark Cleo was wrong, and the jury would have just disbelieved all that stuff because Detective Henson did testify that on June 21st, 1999, Jason Simpson called him and said, little Archie came over and wanted to hit a lick, used that same phrase. And the state is correct. That's powerful evidence that Jason was telling the truth, but the state saw that too, and the state took away that power. The state, back at pages 1643-44, Mark Cleo knew that was a potential argument out there, and he said, there was no mention, Henson didn't say anything about borrowing clothes, didn't say anything about these other things, going in the shower, nothing. And so what Cleo said was, since he was released in March, and that was so much beforehand, we know that this June 21st call was not when little Archie supposedly came and borrowed the clothes. He directly says it. He says, quote, not what we're talking about on June 21st, quote, was not what that conversation on June 21st with Detective Henson was about. So thank you, state. The answer brief shows exactly how material this was and how devastating. Had we had the actual release date of June 9th, that fits perfectly. A few weeks after June 9th is June 21st when he had the call with Henson. So now we have a law enforcement officer confirming at least one detail from this meeting. And a few weeks afterwards is the murder. It fits the timeline perfectly. The state also comes up with this crazy argument about motive, that somehow this shows a motive for Jason if it was closer in time to the murders than not. First off, that doesn't matter. It could be a perfect motive. It could be the best motive in the world. But if providing that evidence of the motive also provided evidence that those clothes left Jason's possession before the murders, all they would prove is that it was a motive that wasn't acted on. He didn't commit the murders, even if he had a motive. but he had no motive. There was never a motive proven, and the way we know that is the prosecutor, certainly no shrinking violet, told us, admitted in the evidentiary hearing, pages 10,998 and 11,007. We really couldn't ascertain what a motive was, could never prove a motive for Jason. They didn't have a motive, and it made no sense. Why would Jason Simpson, who had just been released to be a confidential informant against Big Archie, why would he kill somebody that he's informing against under the supervision of law enforcement? If anything, he had a motive to not kill him. Moreover, the timeline confirms that it was little Archie, not Big Archie. It was little Archie who found out he was working as a confidential informant. So if the motive was to knock off somebody who knows you're working with the police, that would be a motive to kill little Archie, not Big Archie. Nobody killed little Archie, he testified. The state's argument does show, though, that little Archie had a motive, and especially that this was close in time. You know, right before these murders happened, he knows Jason Simpson's snitching on him. He borrows Jason Simpson's dirty clothes, which of course are going to have his DNA. And then those clothes, by all appearances, were planted 4 days after the murder. How could a crime scene investigation team not find these clothes just a few yards away from black material on a barbed wire fence? Material that they knew was relevant, they saved it, and they ultimately matched it up to holes from these clothes. So this evidence was super strong. You don't need to go any further. But we have so many claims. I can't waive these claims for Mr. Simpson, and they are all valid claims. And a bunch of them only make clearer the defense that little Archie did it would have been a solid defense, would have prevailed. I don't know if little Archie would be convicted with this evidence if they ever bothered to try him, but oh my gosh, the evidence that was available either was concealed by the state or defense counsel ineffectively failed to get would have devastated the state's case. First off, we have a newly discovered evidence claim, and post-conviction testimony, little Archie shocked us all. You know, the time that's gone by since the trial hadn't been good to him, and he didn't remember what he testified to. At trial, he denied ever going to Jason Simpson's house. He said maybe he went to his mother's house once. He'd never been to his house. In post-conviction, he remembered going to Jason Simpson's house, not just his house, his trailer. And he remembered some details about it. He remembered being suspicious that Jason Simpson was a confidential informant because Simpson had just been released. Well, that's what Jason Simpson said happened, that he asked him, were you wearing a wine? He confirmed that at the trailer, Jason Simpson went and took a shower. And that while Simpson was in the shower, he found the business card of the detective. These are very specific details that have now been confirmed by the person we think committed the murder, certainly more likely than Simpson to have. And he's now admitted these facts. Now, certainly he didn't admit that he borrowed the clothes because he knew that'd be the end of the gig, but this is devastating. I've already talked about Simpson not having a motive, but there was a very clear motive for little Archie. First off, I'll concede the jury at the trial did hear some of this evidence, although it was indirect testimony through the grapevine, and little Archie saying, well, maybe I told somebody that I was upset and the baby would never see the light of day. That's Kimbler's unborn baby. Would never see the light of day, and I'd kill all three of them. He did say, he admitted he may have said that at trial. There was much better evidence had they bothered to investigate this case a little bit or protect Misty McNeish. They would have known, and we even have newly discovered evidence now from Shannon Elliott. We presented multiple people who testified they directly heard him say this multiple times close in time before the murder. He was going to commit the murders, so he has motive. The next thing we look at is opportunity. Who had the opportunity to get into that house that night? Jason Simpson did not have the opportunity. Remember, Durrance said he went through the kitchen window and then changed that to the laundry room window. Well, just as defense counsel used those photos to show it was impossible to go through the kitchen window, all they had to do was do what I did in our post-conviction hearing. With the same photographs, the same state witness, Detective Chase, looked at those photos. Look, there's photos of the laundry room window, inside and out. There's no way anybody came through that window. He testified that you can look at those. Impossible for anybody to come that way. And this idea that there was a window between the laundry room and the kitchen is disproven by the layout of the house. They took diagrams of where the rooms were. There is no such window. So Simpson could not have come in through a window. Now, Mr. Khalil is a smart guy, and I think he knew that. And because at trial, he changed his theory. He didn't even argue to the jury came through a window. He had a new theory, which was that Simpson came through an unlocked north rear door. And the reason that was unlocked is because little Archie said that shortly before the murders, he was there and he left that door unlocked. And Khalil says, aha, Simpson was waiting in that backyard and went through the open door. The problem is that everybody should have known because they took a deposition of Terry Thompson, who actually testified as a defense witness. Terry Thompson saw his cousin, little Archie, at the gas station right after little Archie had left the house, testified all about it. And immediately after that, Terry Thompson and his girlfriend, Christy Perry, went back to their trailer, which they were moving into, which was on Big Archie's property. So they're now right across the driveway from Big Archie's house. They go and knock on the door. Terry tries the north rear door and it was locked. This is a lock that requires a key to unlock it or to lock it from the inside or from the outside. There is no way Jason Simpson could have gotten in that door. It was locked after little Archie left. Jason couldn't have locked it. He didn't have a key. He couldn't have unlocked it. He didn't have a key. Little Archie had a key and was there. Little Archie was also there with somebody else. He was there with Sean Smallwood. We don't know what Sean Smallwood would say because he hopped on a motorcycle up in Delaware after this case, and the motorcycle blew up, and so he's dead. Or the accelerator hit and he crashed. And he's dead. Like so many witnesses in this case, he's gone. So we don't know what he would say. But we knew from little Archie and from police reports that both those men were there that night within an hour of the murders. And we know that because there was red particulate matter found in Big Archie's digestive tract. And the medical examiner who actually looked at it said that was eaten within an hour of death and is consistent with cherries or strawberries. And that's important because that's what little Archie said they were doing. They were eating processed cherry pie or strawberry cake or whatever, some red particulate matter. So we know two people were there within an hour of death. One of them had a very emotional motive, hated his father for what his father was doing, and it's a brutal murder. This isn't an assassination of him. This is a gruesome axe murder. And moreover, this is an axe murder. There's pictures of the blood everywhere. It is physically impossible. Jason Simpson or any other human being on this planet could not have committed this crime wearing that shirt and hat. Could not have possible. They could have been standing aside. Prince could have been wearing them and standing aside, but they couldn't have been committing the murder with the axe because there's not a drop of blood. They were wearing a hat. No blood on the hat. They were wearing a sweatshirt. No blood anywhere on the sweatshirt, not even the sleeve that was holding that axe. This is gruesome, but close your eyes for just a second and think about what would happen if you're wearing a shirt and you hold an axe and you axe somebody lying in bed repeatedly, causing all these gaping wounds and blood to go everywhere. You have blood all over your sleeve. You have it on your Counsel recognized, Eller recognized, ooh, that's a good theory. That fits like a glove, he said, with our defense. I think I planted that seed. No, he didn't. Read the closing argument. He never made that argument. He could have had a crime scene expert tell a jury. It would clothe it in an expert's opinion. We provided one who made it very clear that it's impossible. But even without that, it's common sense. Little Archie knew the position of the bodies. There was evidence at trial that he told Detective Williams 4 days after the murder that he knew the position of the bodies, very uniquely. He knew Big Archie was dead in the bed and little Archie was laying on the floor with her foot up on the bed. Very unusual posture. He could have only known that if he was in that room committing the murders or if a family member told him, which was the state's theory. And if it was 4 days afterwards, that makes a lot of sense. That's plenty of time to hear. But defense counsel wasn't prepared and just simply wasn't reading the report correctly. He had the report in his hands and Williams on the stand. And the prefaces of his question was that this conversation took place on July 20th, 4 days after the murder. But that's not true. All you got to do is look at the report. We put it in evidence. We had Williams testify at the evidentiary hearing. He confirmed, no, that was the day after the murders. The day after the murders, when little Archie shows up, the police are already there. He shows up, he runs towards the scene and is immediately arrested before he can talk to anybody. He's immediately detained, put in a patrol car where he stays. He's taken to the PMB, Police Memorial Building, and he gives this incriminating statement. Had the jury known that was the same day, Oh my God, what's more incriminating than that? And if there's any doubt at all defense counsel had to do.
Counsel,
yeah.
You are now into your rebuttal time by a couple of minutes. You can continue, but I just wanted to bring that to your attention.
All right, well, thank you. I've requested 90 minutes. It would take that to get through all these claims. These are serious claims. We have DNA evidence claims. We have destruction of evidence claims. Durance recanted. We met the test the court refused to even apply. And the court found Durance wouldn't even come testify now because of the recant. That's what we need to prove. We don't need to impeach him because he won't testify to this again. He's admitted to me and our investigator that he lied. He gave us the details where they came from, including a quote from a Dean Koontz novel. He said that. We had to go look it up, and sure as hell, 1999, right at the time of the murders, there's a Dean Koontz novel talking about Wetmore. I'm going to have to reserve because I do need some time to hear what the state says. But all of our claims merit relief. Cumulatively, they show they can't convict Mr. Simpson in a new trial, and he should have his conviction set aside with prejudice. Thank you.
Thank you. Counsel.
May it please the court, Michael Kennett for the state of Florida. This was a gruesome murder. It was an axe murder. I'll lay out the evidence very quickly. There are three legs of a stool is how the defense described it. You have the confession from the appellant to Durance. You also have the DNA evidence of the black sweat clothes that were found behind the air conditioner, behind the church, which is behind the home owned by the victims. The victim's blood DNA was found on those clothes, as was wear DNA from the appellant. There was also some suspicious behavior that was testified to about the appellant's behavior after the murder. So those are the three legs of the evidentiary stool for the state. The appellant started out his oral argument by talking about some overarching themes. I'll respond to those very briefly and get to claim 17 very quickly. But as far as cumulative prejudice goes, there's no cumulative prejudice analysis unless there are multiple errors. Here, the trial court did not find a single violation of Brady, Giglio, Strickland, Youngblood, or a single claim successful for newly discovered evidence. So there's no cumulative prejudice, there's no cumulative materiality possible because there have been no violations, let alone multiple violations. And the law is very clear on that. Second, I just want to highlight, this is not a civil trial where the initial brief is like a pleading. Just because the state did not respond to every single argument raised in over almost 400 pages of briefing doesn't mean that the state admits any of that. This is not a civil pleading. This is an appeal in post-conviction where there are significant finality interests. And the decisions of trial courts come to this court cloaked with a presumption of correctness. So even if the state does nothing in a case, that lower court decision still comes here with a presumption of correctness, and the appellant refuses to acknowledge that. Now, as to why we're here to review the trial court's decision to deny an initial motion for post-conviction relief in a death penalty case. There is a standard of review that applies. Is there a competent, substantial evidence to support the factual findings relevant to that claim? And under de novo standard, did the trial court correctly apply the law? But what you don't see in the almost 400 pages of briefing in this case is any detailed analysis such as, here are the findings of fact the trial court made associated with this claim. Here is why these findings of fact associated with this claim are not supported by competent, substantial evidence. Here is the legal conclusions that the court drew. Here's why they're incorrect. What we see over and over again in those almost 400 pages and in the oral argument is just constant reassertions of factual innocence. But we're beyond that. All this evidence about inconsistencies, about motive and opportunity, it was all before the jury. The appellant testified, Durance testified, and little Archie testified. The jury was able to make credibility determinations, and the jury rejected the testimony of the appellant and found him guilty. We are in post-conviction. The focus is on legal errors, and did the trial court make a mistake when it denied the claims for post-conviction relief?
Counsel, could you address issue 8, the Brady claim about the failure to disclose little Archie was a confidential informant in another case?
He was not a confidential informant, and the trial court found that correctly. Now, there is some evidence that the state or law enforcement did use information that was provided by little Archie, but there was no agreement. He was not a confidential informant. He was not paid for his testimony. He wasn't given any kind of negotiated plea or sentence in a case for cooperating. He just provided some information. And so it's not a Brady violation. It's not Brady material, as the trial court found, and there's no materiality there, which the trial court correctly found. Now, turning to claim 17, underneath that claim, there are two subclaims. One is a Giglio claim. The other is a Strickland claim. And it's interesting that the appellant argues that a question posed by the prosecution to the defendant during cross-examination is a violation of Giglio. But Giglio is very clear that the first prong of Giglio is that there has to be actual testimony. And a question posed by the prosecution to a defendant during cross-examination is not evidence. So it fails the first prong of Giglio. Second, the defendant would have to show, or appellant would have to show, that the prosecutor knew it was false. But here, there's no evidence of that. Quite to the contrary, there's evidence that the appellant was released from Duval County Jail in March, and that is what the prosecutor referenced, and that's what the trial court found. In the trial court's order, on page 131 of the order, the prosecutor referenced the March 1999 release was from Duval County Jail, rendering those statements true. So it fails the second prong of Giglio. And going to the third prong, the trial court correctly found that it was not material. Little Archie's testimony that he went to the defendant's home within a few months of the murders is consistent with the defendant's testimony that little Archie came to his home prior to the murders. When exactly this occurred is immaterial. The reason why the appellant argues that this is important is because he says that's the time that little Archie supposedly took the clothes from the appellant. But you have, as the trial court found, the testimony of Detective Hinson corroborates the appellant's version of events. That the statements of the trial court found Detective Hinson's testimony supports the defendant's statements that the visit to the trailer occurred in June of 1999. So there really is no materiality there. There's also no prejudice under Strickland for that same reason. And as far as the deficient performance prong of Strickland, there's no deficient performance because the defense counsel said in post-conviction, look, or the trial court found in post-conviction, look, to clear up that ambiguity regarding the release date, the defense would have to admit that there was a second criminal violation in Columbia County. In other words, to show that I was released from Duval County Jail for my Duval County offense in March, but not June, I would have to admit that there was a separate crime that occurred in Columbia County. It's very reasonable for the defense counsel to say, I'm not going to go there. It's not worth it.
Could I ask a question? Would you address the argument, which sounds reasonable, that it's difficult to conclude that the date of release was not material to the impeachment, the way the impeachment played out, given the prosecutor's reliance on that repeatedly in closing argument?
But it's a fair question, but to some extent, that's not a valid post-conviction claim. That would be a more appropriate claim for direct appeal, not post-conviction. If you're focusing on the prosecutor's question, if you're focusing on the prosecutor's closing argument, that is more appropriate for direct appeal, not post-conviction. Now, again, if you're trying to argue that under Giglio, the prosecutor knowingly elicited false testimony, okay, but we've already argued that, number one, it's not testimony because it was a question. Number two, it wasn't false because he was released in June. And there's no argument sufficiently that the counsel was ineffective during the closing argument for not addressing that particular point. I hope I answered your question, Justice Lawson. But that's claim 17. Again, there's a lot of arguing the facts in this oral argument. There's not a lot of focus on the standard of review. Is there competent substantial evidence to support the factual findings? And did the trial court incorrectly apply the law? That's missing in the oral argument. It's also missing in the briefs. And then just to address, I think it's claim 30 about little Archie and whether or not his testimony in post-conviction now supports an alibi defense where it didn't before. I think it's important to highlight that during the trial, little Archie was asked a compound question. It was basically three questions in one. Did you go to the trailer? Did you see the business card? And did you take the clothes? Little Archie always maintained before trial and in post-conviction, he never took the clothes, he never killed his parents or his father and his father's girlfriend. So absent any additional questions from the court, the state asks that this court affirm the trial court's denial of the post-conviction motion. Thank you very much.
Rebuttal.
My friend did note that there was some circumstantial evidence. That's about the pager, about an injury on the hand, about leaving an interview. We deal with that was minor evidence, and we destroy every single piece of it in our final claims in here. But most of them were as a result of the police unintentionally giving us their handwritten notes taken at the time, which contradict the police reports that they prepared after they thought Jason Simpson did it many years later, after the Durant's confession and the DNA. And all of those claims, these were mildly suspicious circumstances, and none of them were true. The last person to page Big Archie was Little Archie and Sean Smallwood and Little Archie's mother's house. We didn't address findings of fact in the court's order because there were very few that were unfavorable to us. They're almost all favorable to us. The few that aren't supported by competent substantial evidence, we've addressed. I addressed some already. Most of the issues are just applying the law to the facts, and that's the no vote. Doesn't matter what the trial court did. Justice Polston, you asked about the claim about Little Archie being a confidential informant. That's actually claim 15 from our petition, and we proved it. There's no question. We did not prove. We think he was a confidential informant in a broader scheme. We didn't prove that, but we did prove he was a confidential informant for JSO against, of all people, Mike Durant. We know that because his name's in the wiretap affidavit. That same wiretap affidavit where Jason was working as a confidential informant said confidential source number 1, I think it was. We proved that was Little Archie, and that Durant's figured out it was Little Archie and knew Little Archie had said this. And not only was Little Archie saying that Durant's was doing drug deals, Little Archie told the prosecutor here, Mark Khalil, that Durant's murdered Wayne Schmiedes, a drug dealer in West Palm Beach. And we know that after this trial, they charged Durant's with that crime, and Little Archie went down there and testified, and they played Durant's testimony here that he would lie under oath, and they convicted Durant's, and he's now serving a life sentence for that murder. So absolutely, Little Archie was a confidential informant against Durant's. He was working for the state. The state had lots of reasons to not point the blame to him. That was important.
So what difference did that make in this case?
It showed why the prosecutor didn't go after, they didn't investigate Little Archie. They let him go almost immediately afterwards. They've never arrested him for anything, the federal government has, but they didn't look at him as a serious suspect in this case. Instead, they went looking for somebody else, Simpson, even though all the evidence we've discussed points to Little Archie. And as for this idea that I agree with my brother, defense counsel absolutely should have objected at closing argument when Khalil started saying all this. We have an ineffective assistance claim. That is a post-conviction claim. That's where you're supposed to raise it. And it was ineffective because Eller could have done 2 things. He could have just objected, moved for a mistrial because the state attorney, who certainly knows when people are released from jail, has made a false representation to the jury. So that should have been a mistrial. Or he could have just come back and said on his closing, there's no evidence of that. You can't convict Simpson based on.
I know that you don't have a lot of time left, but could you address the argument, which appears to be correct, that the Giglio claim, your claim 17, requires false testimony, and you haven't put forth any false testimony?
It does not require false testimony. It applies, and we've cited cases, and I'm sorry I don't have them handy. They're in both our initial and our reply brief that make very clear that a representation of fact by a prosecutor can be the basis for Giglio. The fact that he didn't testify under oath about it is irrelevant. When the prosecutor says, the person before the jury who's in charge of law enforcement in the jurisdiction, who is speaking for the state, who has access to all these records, when that person makes a representation that the client, the defendant, is lying because, hey, we've got these records, we know, and he did that with other things too. I mean, look at our closing argument issue. There's lots of them. They would require relief in a civil case. Certainly they require relief here. There was bolstering. The state said, we've got more evidence, and the March 1999 was just one more example of that. You should free Jason Simpson. He did not commit these murders. At the very least, you can have zero confidence at all that a jury hearing the truth would convict him. But if you disagree with me on that, give him a new trial. We're ready to go. They don't have a prayer. Thank you.
Thank you. We thank you both for your arguments, and that concludes this session of court.